Okay, good afternoon members and welcome to our meeting. Just to remind you that the meeting is being broadcast online and throughout Parliament buildings, and welcome to anybody who is watching online today. If you can ensure your mobile phones are muted, and just to remind you that recording and photography of the meeting is not allowed. Okay, members, we're going to proceed with the agenda. So, in terms of apologies,
Chair, we have Claire Sugden and Philip Brett have both sent their apologies.
And Anya's running late.
Yes. Okay, thank you. I think everybody else is here. Okay, so members, are there any declarations of interest to declare in relation to this meeting? No. Okay. Okay, so chairperson's business. So members, I'm going to refer you to pages 6 to 9 of your meeting pack, and this is in relation to an individual contacted us regarding concerns around the proposed redevelopment of the Marion site. Yes. So I hope you'll have had a chance to read that letter, but it's concerning the redevelopment of this Marion Mother and Baby Institution and Magdalene Laundry site in Uri, and the proposal to change it into commercial and industrial units. The 2021 report commissioned by the Truth Recovery Independent Panel outlined the call for memorialisation and preservation of institutional sites as places of remembrance, educational reflection, and the report emphasised the moral and social responsibility to ensure that these locations are not subsumed into commercial ownership and usage. So members, I'm going to seek your agreement to forward this correspondence to the department and ask the Truth Recovery team what engagement or discussions they have taken place regarding the site and any potential memorialisation. So just before I bring you in, Timothy, so this, I have already contacted our councillor in Uri, because obviously there's a planning issue as well there, so possibly individuals will be dealing with this on an individual basis, but I just wanted to put that on the record. Go ahead, Timothy, please.
My concern with this is that when you take Concora, there was a long, drawn-out public wish to have the building demolished. So I respect that this person in particular wants to have a memorialisation at the site, but there may also be people who would like to see the end of it. So when we are forwarding on, I think we have to take that into account, that in the past, when it came to Concora, there was quite a public push and public presence, and it was made clear that a lot of people wanted that building gone. So I think we have to look at it in the context of there will be people probably want to see Marionville tumbled to the ground as well, because they don't want that reminder of what had happened on that site.
I think the issue, Carol, sorry, I think the issue as well is the issue of the unmarked graves and a lot of that unsettling of the land. So I think there's a lot to it. Go ahead, please, Carol.
So some of the stakeholders this morning raised this, and they're concerned about the unmarked graves. I mean, Timothy's point right about Concora, there was quite a lot of opinion to have it just levelled. And to be fair, I mean, people who were impacted by Concora got no justice whatsoever. But the issue here is that industrial units, and it will be a planning issue, although we can talk about the concerns that have been brought to us. But we need to make sure that there isn't like a wee plaque stuck in the corner of some unit that's selling remold tires. I mean, that's horrific. But was there a survey done on that site before?
Yes, I think we should maybe try and get like a
I think there was.
There has been, and it's a long drawn out process in terms of them going down and commissioned surveys of the site and stuff, and then the dispute over some of the information that came back and other people's recollection who were there at the time or have done their own research. So it's maybe something we do need to pick up, but I'm conscious that the time is maybe against us in terms of committee, and I think that's why we need the Executive Office's intervention.
The letter that we're sending to the Executive Office, would it be appropriate to send it to the council?
Yes. I think that there's a piece of correspondence. There's two gentlemen, I don't want to name them, but I think one of them I saw that they had copied in the council as well, but I think that probably just from our own point of view, we should maybe forward both.
It's just that I think we're duty bound to raise concerns, to be honest.
Stuart, please.
Yeah, Chair, I think this raises a range of issues. This is not like Kincora's site at all. I mean, in the sense that there, to the best of our knowledge, there are no unmarked graves on that site. And I think that's what perhaps separates this out, separate from the potential abuse which happened at the site. I think it given that there's a clear intent and it has been stated publicly that there should be appropriate memorialisation of sites, that I think we need to inquire as to the whole background to the sale of this site. The original owners clearly decided to sell it. Did they sell it in the knowledge of what it was going to become? And did they sell it in the knowledge that it is a very sensitive site for people concerned? And I think they need to answer our questions in respect of it. I could actually get quite angry about the behaviour of the original owners of the site, allowing it to get into this set of circumstances we find ourselves in. I think there needs to be appropriate memorialisation on the site. As Carol and others have raised, the nature of the site makes that very difficult. And if there is an area of unmarked graves, then I think that must be taken into account by the planners in respect of this. And it is a case of buyer beware.
I'm sorry, can I just bring Pam in and bring it back in then? Go ahead, please.
Thanks, Chair. No, it was just to say that I had similar thoughts actually around just the sensitivities of the whole thing, and there will be lots of different varying views, as there always are, around this incredibly difficult issue, and I appreciate the unmarked graves issue as well. So I completely support reaching out to the department to get further information and maybe get some form of brief and to see what's happening with that. I think that would be appropriate.
Okay, Timothy, do you want back in?
Yeah, I'm very sympathetic to the unmarked graves. I suppose my query is this a site of interest for the PSNI still? Another thought process would be that during the inquiry, dear knows what information might come forward, and to make a decision at this stage may be premature. My point at the start was about keeping the building. People will want to see it tumbled, but at the same time, unmarked graves, the police need to be fully supportive, and all the archaeological digs have taken place, and we are assured that there's no unmarked graves in that site.
Yeah, disturbed. I suppose just to pick up on a point that was raised this morning as well, and that is around this programme of memorialisation. And I had a chat with a few of the ladies afterwards, and whilst I think a lot of them do want to see something on the face of the bill around this, I think that might take us outside scope, but at the same time I don't see why there would be an issue with the Executive Office, for example, commissioning the Arts Council to do some facilitative work with the consultative forum with a view to taking it forward. I don't think it needs legislation. I think it's maybe just more of a programme. So I think maybe in that context, and given what we have been hearing, not just in the roundtable but in our evidence session, see if there's any thinking within the Executive Office around memorialisation in its broadest sense.
So, but, this is a completely different issue, but on the same theme, there's lots of things that aren't in the bill but are raised, and it's about acknowledgement. So even today, you've seen some of the frustration that we were only looking at certain clauses. So not even just today, but previous to this, if the department are going to go by maybe like a COVID modular approach or whatever, there was room at the start for testimony. And it did come up today in terms of, while the money is important, it is acknowledgement in terms of redress, but also part of that redress and acknowledgement is the way in which they're heard, their experiences, and that come up around dates as well. So in terms of that individual writing, I think if we wrote to TEO and copied that letter into Newry and Mourne, or whatever they're called now, is it Newry and Mourne?
Yeah. And the police.
What is it?
And the police.
And the police, yes.
Okay, I'm conscious that our first session is actually, we're going to be going through the main, so we're going to get a summary, so we can maybe pick up some of those broader points in that.
I'm going to get my glasses.
Okay, so are we in agreement then for that proposal from Carol with the additional bit from Timothy in terms of PSNI? Yes?
Yeah.
Okay, I'm going to move on. We'll say we will come back to this in more substance in a minute. Okay, 3.2 then. This is an invitation that I have received to attend the Interparliamentary Forum this year. You'll find that on page 10 of your meeting pack, and this just to advise that I've been invited to the next session of this. It's in the Welsh Senate, and this forum brings together representatives from across the UK's legislatures to discuss key constitutional and legislative developments. I'm usually accompanied not just by the clerk but also by the chair of the Finance Committee as well, and the clerk for that committee. So it is very useful just to advise that I think we are going to accept the invitation, yes, and I will provide an overview at our meeting on the 3rd of December. Just ask you to note that. Okay, 3.3, betrayal trauma training. So just to advise that Wave Trauma Centre has offered members in the committee team the opportunity to avail of their betrayal trauma training workshop aimed at institutional trauma, complex trauma, betrayal, blindness, shame and healing from betrayal trauma. This will be a one-day course facilitated by Dr. Paul Gallagher, and it will be on Monday the 15th of December. You'll know we go into recess on the 13th. So just to advise that if any members would like to attend, could you please email the committee team by Monday of next week. Okay. So the Europa Roundtable event, I think all of us were at that this morning. Just to advise that we have now held our third and final stakeholder roundtable event in relation to the bill. This morning it was in the Europa Hotel, and I think in total the committee has now hosted over 90 individuals at these events, and it hopefully demonstrates the committee's desire to have as many views as possible heard. Just to advise, the Hansard of these events will be included in the committee report, and just acknowledge that it was great to see so many committee members there today. I know Sinead, you were at the one in Omagh last week, and Anya was at the one in Dungannon, so I think we've been very well represented across the three events. Does anybody have anything to say about the events at this stage? Anything to comment? No? No, but I would certainly echo Stuart's thanks to the committee team for their organisation of it. I think it went really well.
Thank you.
Okay, so moving on then, members' draft minutes. You'll find these on pages 12 to 22 of your pack, and these are from our meeting on the 8th of October. So if you're content with these minutes, that they're a true reflection of the proceedings, I'll go ahead and sign them. Okay, so matters arising. So members, I'm going to refer you to pages 24 to 26 of your pack, and this is around the Historical Institutional Abuse Redress Board, and it's around their retention and disposal schedule. So the committee has been sent the most recent retention and disposal schedule for the HIA Redress Board. The schedule is subject to the negative resolution procedure, and any member or committee may seek a resolution to pray for the preservation of specified records in the retention and disposal schedule. In line with the principle that Assembly committees have a role in scrutinising the action of their respective departments, the retention and disposal schedules will continue to be sent to the Committee for Communities. However, they may not be best placed to scrutinise retention and disposal schedules of public bodies that do not fall under the remit of that department. So just to remind you that the retention and disposal schedules that are sent to the committee are required to be treated in much the same way as any statutory rule, and also to advise that the time frame for committee consideration of this schedule is very tight. The members must come to a position on the schedule before the 20th of November, and given that it needs to be considered by two committees, and if a motion is sought, it must be tabled and debated in plenary before the end of the statutory period, and the clerk has, on behalf of the committee, requested further information on this schedule. So just wanted to know if you have any comments on this schedule. Go ahead, please, Timothy.
Just a quick comment. Obviously, retention of records and access to records is something that's come up quite a bit over this last number of months. I suppose I'm particularly perturbed by what the trusts have come back with. Yes, it's good to have the records, but they need to be kept in a usable form. My belief is anything that falls under DFC or any of the departments now should be digitised to safeguard them from future, and that they're kept in a good condition, because a lot of these things will be used for stats in the years to come. So on the basis of what we have heard at this committee, I think there's an onus on us to start to probe now of how some of these records are kept, and there should be, going forward, that these are all turned into digital records. I particularly think of the Western Trust, where we heard, was it last week or the week before, a couple of weeks ago, where concerns about the building they were kept in, the climate, and also that they could be accessible to pests. I think of then the story this week about the Enniskillen bomb, that records were destroyed because of asbestos. So I think there's a duty on government now, based especially on what this committee has heard, that we ensure that any records that are being kept are kept in an accessible manner, they're kept digitised for future preservation.
Yeah, go ahead please, Deputy Chair.
Yes, last week I had a visit to the Public Records Office, a really interesting behind the scenes, and these are some of the areas that I discussed with them. Digitising records is extremely complicated. It is a very slow process. Each document file has to be opened and scanned in order for that to happen. It's labour intensive. You might think this is an easy mechanical process or digital process. It is not. It's an extremely intensive process. It's also a very expensive process. So it does take a very large amount of time and resource to do that. So I think the concern would be is I think we have to accept the time frame, but I think we need to be sure that the Public Records Office has the requisite resource available to do that particular work, and that those authorities which currently retain, like as Timothy says, the Western Trust and others that retain records, that they take on board the advice that's given to them by the Public Records Office with regards to retaining those documents in the meantime.
I'm concerned, this actually came up in the after roundtable chat I had, and it was around this sort of disposal or retention and disposal, especially for historians in the future who may want to access these records. So I think that the proposal from the clerk is that we consider the schedule at our meeting on the 12th of November, and the clerk will be in a position to provide further information on the rationale for the timescales of the schedule at that meeting. But I do think it's maybe something we do need to have a bit of a deeper dive in, because it will have implications then from other baby institutions as well. Go ahead.
Yeah, Chair, I think, and it's just declaring interest, I used to be responsible for PRONI, but I think we need to go further. So we'll have to go through the procedure as laid out, but I mean, as part of the ongoing cost of the inquiry, I do think there needs to be money given to PRONI. I think there needs to be a request for all the records from all the health and social care trusts to be deposited in PRONI, for them to do the digitisation, because at the minute they're talking about and employing a band 4, I think it is, in one of the trusts. Now they mightn't do it, but because it has to be on request. But at this stage, I mean, depending on how they're managing their files and records, particularly since, you know, the 40s and onwards, it's a big concern. So, I mean, at the minute, that part of the trust comes under health, but DFC are responsible for PRONI. And I just think we need to ask, you know, what anticipation of this inquiry, what actual arrangements are making.
And Chair, if I may, that's actually something that we'll come on to later on in the meeting, that the Committee for Communities wrote back to this committee in relation to its call for evidence on the bill, and one of the things they brought up was that very issue that as they have a responsibility for scrutinising the work of PRONI, they were concerned around what impact it would have, and also what PRONI were doing. So I think that Committee on Communities have already sort of got this on their radar, but certainly we can contact directly and ask those specific issues.
But PRONI are governed by the Article 2, and they're governed by the FOI route and the non-FOI route. So it's that legal undertaking which is in statute now. The trusts aren't. And they'll probably say something along the lines of, well, there are records and we'll hand them out upon request. Either the trust PRONI or they don't. I mean, that's the way I view it. And it should be deposited in PRONI until such times are not needed, and if they're not needed, they're handed back. Because I think these people have been through enough without going through another layer of bureaucracy. I mean, the Trust were supposed to have all this bottomed out with the adoption bill that we went through, and they haven't got it. They haven't got it. So,
Chair, if I may, for me, actually, that's something else that we're coming to. We'll come to the trusts themselves and the letter that
Yes, that's right.
the committee are proposing to write to the Minister of Health on this subject as well. But I certainly made a note of those concerns, and we can contact Peroni directly around that as well.
Pam, please go
I
ahead.
suppose declaring interest as a member of communities. I'm actually going down to see Peroni on Friday morning myself to see how it all happens. So that should be very interesting. But it is a huge, huge issue. I think it is important that obviously Peroni have the appropriate resources as well to deal with the huge capacity of information. So completely supportive of that communication to look into this further, because it is really, really important. I think there's nothing more frustrating for survivors than this access to records issue.
Okay, so I'm just going to formally seek the agreement then that we schedule this, for the committee to consider the schedule at this meeting on the 12th of November, and that the clerk will then be in that position to provide further information, the rationale for the timescale. So we agree that. And then the second issue was Carol's suggestion there around writing to, is it to the Department for Communities around Peroni, or is it to TO?
it's both.
Peroni
Well,
themselves?
yeah, I mean, first of all, I think we need a right to health.
And we will come.
Okay,
Sorry,
well,
Chair,
we'll
So
we'll
we're going to
to
come
that.
up to that,
We're
but
gonna come
certainly
to
the communities and TEO.
Yeah,
I
okay.
mean, TEO, whatever communities need for Peroni, it needs to be considered because it's really important.
The resources issue then, so we'll write to... Go ahead, please.
I think, Chair, it might be useful, not necessarily at the moment, but at some stage for the committee also to meet with or go to Peroni to get a full understanding of this. I think there are some misconceptions around some of the records. In talking to staff directly involved with some of these records, particularly those involved coming from the charities, which have not been easy to get. Many people will be extremely disappointed to discover that the record consists quite often of one page, and on that page is one line.
Exactly.
Baby born, end of story. So these are not vast bundles of documents. I think when it comes to social work documents and trusts, that is a different situation. But there's a vast range of things, and I think it's something which I think we need to get a handle on.
I think as a committee,
Very
just
small,
quickly,
go ahead.
it's the trust records, and I know we're coming on to it. That's where the concern has been. That's where we have been told that there's a trust in particular. One hadn't come back at that stage, and one has left, leaving us with serious concerns about the condition and where the records are being kept.
Yeah.
Okay. We'll come on to that
We will come
later
on
on.
to that, yeah.
Okay, thanks. So we've received a further submission on behalf of KRW Law. And you'll find that on pages 48 to 53 of your pack. And this is around with information regarding the potential application of public interest immunity within the inquiry following their oral evidence session on the bill. We received that on the 8th of October. And just asking your agreement to note this, or has anybody got any? I think we'll probably look at that.
I think we'll come back to it when we do our clause to clause.
Yeah, deliberation, yeah.
Yeah.
Okay, thank you. Okay, members, so the draft letter from me to the Health Minister regarding access to records and the Belfast Trust response. So I'm going to refer you to pages 54 to 57 of your pack for a draft letter from the Committee to the Health Minister in relation to the access to records and the bill. Just to advise that all responses have now been received from the 5 Health and Social Care Trusts, and the response from the Belfast Trust can be found on pages 58 to 60 of your pack. So I'm asking you to your agreement to note this item and to see if you have any views on the draft letter. I thought it was fine.
I think it's grand.
Okay. Any other comments on that issue, or do you want me just to pause for that?
We just need agreement to actually send the letter.
Yes, so sorry, agreement to send the letter. Okay,
Agreed.
thank you. Okay, so members, 5.6, you'll find the draft press release from the committee following our visit to the Maze Long Cash Development Corporation. You'll find this on pages 3 to 4 of the table pack. Just to advise that the communications team has drafted this draft press release in advance of our visit to the site on the 5th of November, and then obviously it'll be amended and updated once we have had the visit. So it's just to see if you are content with the draft press statement as has been drafted. A minute, go ahead.
Yes, contempt, Chair, but just to note that I won't be available for that visit.
Okay.
Disappointingly, actually, but
Oh, no problem.
I'd
Thank
like
you.
to have been there.
Okay, so just seek your agreement for this to be published following the committee's visit.
I would rather wait till after. I haven't been to the site before. I would rather wait till after we've
And then
been there.
Okay.
Sorry, Chair, that's
That's
what
after the visit.
Yeah,
Yeah.
it won't be published till after the visit.
I know it won't be, but I would
It can be
rather at
altered.
that stage if there's any additional comments as well.
That's fine. Okay, members, we're going to move on to item 6 on the agenda, substantive item. So this is a summary of the bill's scrutiny to date on the inquiry, mother and baby institutions, Magdalene, Laundries and Workhouses and Redress scheme bill. So I'm going to seek your agreement for Hansard to record the session.
Agreed.
Okay, members, refer you to pages 75 to 84 of your pack for the clerk's brief and pages 85 to 144 for the summary of the written evidence received to date.
Very good.
Yeah, so I'm going to ask the clerk to speak to the written evidence to date.
Thank you, Chair.
Okay, thank you.
I won't, you'll be pleased to know, be going through pages 85 to 144 of the pack, because I think that would take us all day. But what I was hoping to do, members, was just to highlight some of the main issues that have come out of the 80 plus written submissions that the committee received as part of its call for evidence, and really you can follow along on that on the brief that I sent to committee. So that's pages 75 to 84 of the pack. Just as a reminder, our formal call for evidence was launched on the 7th of July, which seems a long time ago now, and it closed on the 29th of September. We had 59 citizen space responses. We then had a further 20 official written responses for the call for evidence. We have then since then continued to receive correspondence that will form part of the submissions that will come into the committee, although they won't formally be part of the call for evidence, but obviously the committee will still consider them. So you'll note that I've gone through each clause and have tried to summarise what the committee has heard from the written evidence, and then in some cases some proposed actions that I wanted just to flag to the committee, and perhaps that's something that we can either agree or think about as we go through. So the first ones to highlight really are clauses 1 to 4, and I will say that we received a large number of responses on these clauses, which is not really unexpected. Just to say, in terms of clause 1 on the inquiry itself, many respondents did think that the scope of the inquiry is currently too narrow, and again we heard this at the evidence session today and at the ones that we held last week, that on a number of fronts it's too narrow in terms of the institutions or even the type of organisations that it's looking at. So there were calls to include private nursing homes, private baby homes, and then other non-institutional settings. There were also a number of concerns raised about the exclusion of HIA survivors from the inquiry, and we did have one query about whether the inquiry should whether things that were investigated by the HIA inquiry should be looked at again by this inquiry or not. An overwhelming theme coming from the written submissions that comes clause after clause after clause from a majority of people is a desire for a trauma-based, victim-centred, human rights-based framing, particularly of the inquiry. And again, Chair, I think we heard that today at the evidence session this morning and at the ones last week. So I just wanted to suggest that members may wish to consider when we come to our deliberations on the bill, which will start after recess, whether other institutions would be within the scope of the bill as it's drafted, considering the title of the bill itself. That's something members may need to look about. And I wanted to note as well that the bill, as it's written at the minute, the prescribed list of institutions can be added to. It can only be added to with Assembly approval. So it's not that the bill allows either for the inquiry or for TEO to just change it. They can propose changes, which then come to the Assembly via
That's like an
via
amendment,
regulation.
a committee amendment.
Well, it would be once the bill has happened. It would then be it would come as a stat rule, as a regulation. If they decided that they wanted to change that, that may well be when the inquiry first starts.
I prefer we done it as a committee amendment.
Yeah.
Which, of course, is another
Yeah.
option for us. I just wanted to flag up more that it's not as if it can be changed by either inquiry or DFM without Assembly approval. So I'll press on because there are a lot of clauses to get through, if that's okay. So Clause 2, the terms of reference. Again, something that has come out from many of the submissions is that members of the public and victims and survivors really want a clearer definition of what's meant by systemic failures. That is quite a broad term, and although a definition may not require to actually be inserted in the bill, I think it may well be worth members seeking clarity on that before we come to a conclusion in terms of the report. Members should also note that there is a strong support for all actors, as I've called them, so state, religious, private, to be included in the terms of reference. A number of submissions highlighted omissions to the terms of reference, in particular adoption agencies, again private baby homes, and again it's something we heard this morning, Chair, networks or pathways, informal networks and pathways is not something that is in the terms of reference at any point. So again, my proposed action here is that members may wish to consider whether inclusion of these bodies is something that can be done via amendment, but also to be mindful of what is the relatively narrow scope of the bill in terms of its title. But certainly to ask TEO perhaps for a further definition of what systemic failings means in the context of this bill. Clause 3, prescribed institutions. Again, much comments on this clause. Submissions mostly did show support for flexibility in relation to the institutions included, and that is, as the bill is written, there is that flexibility. However, concerns were raised over a lack of transparency in relation to decisions made about this clause in the drafting process. So in other words, a number of respondents were asking why were these particular institutions included and other ones not. And again, that's something that members may wish to get from the department in terms of the criteria around why certain institutions were listed as prescribed and certain weren't. The EFM goes so far, but I think there is perhaps more detail that could be in there. And also, again, as I've noted, just to make members aware that anything to be inserted into that bill may well come in regulation once the bill becomes an act. Clause 4 is the last of the big ones for the first section, really, and that's obviously relevant persons. And I have to say there was overwhelming support for groups included in the bill. However, again, we heard this in two of our stakeholder sessions and in a number of submissions. There were calls to include birth fathers as relevant persons. That was the single biggest area that wasn't currently included in the bill. However, other siblings, extended families, and those affected outside of institutions but not related were also called to be included in the clause. May I suggest that members might wish to seek a rationale for the department on not including any of these groups rather than a rationale of the groups that it included, because we already have that in the EFM, and that may well help the committee in its further deliberations. And again, some concerns, although I have to say not by a large number of respondents, over about the apparent inclusion of adoptees and intergenerational victims. And again, Chair, as we were mentioning earlier, that's something that was raised at the evidence session again. But I would suggest that perhaps that's something members can consider in the clause-by-clause scrutiny.
Yeah. Go ahead.
Just quickly, one of the discussions that came up this morning was clause 4.2. So when it's talking about the definition of a relevant person, and that goes on to say the Executive Office may by regulations provide that persons specified in the regulations who would otherwise be relevant persons are to be treated for the purposes of this section as if they were not relevant persons.
Yes.
So the question this morning was, what does that mean?
Well, that is something we can ask the department. I would not want to give an answer myself because, you know, it's
somebody. I was asked at the table this morning, what does that mean? Because we're detailing relevant persons, but then we look at clause 4.2, and then for the purposes of this section, basically people are treated as if they're not relevant. So to me, it's contradictory. It's something I couldn't answer this morning, so if we could get clarity in that before we go to the clause by clause.
I'm happy with that. No problem, that's fine. Clause 5, which is in relation to the inquiry panel, there was a clear and a majority preference for multi-member panel with diverse expertise, not a single-person panel, obviously, which is a bit of an oxymoron. The majority submissions also wished for survivors to be consulted on the makeup and composition of the panel, and again, I think this would be something that would be reflected in future regulation and guidance as opposed to actually on the face of the bill itself. Concerns were also raised about impartiality and the lack of legal accountability for the panel, but again I would like to stress that that was a minority of submissions received. Members may wish to seek departmental clarity on guidance that might come forward around the composition and selection of panel members. But again, that's something perhaps for deliberations. That really runs into clause 6, which was the appointment of members, and again, survivor involvement is a key from the submissions on that in any appointments made, and also transparency and independence was something that many respondents were interested in and wanted to be known. And again, I think we can ask for clarity from that, whether that will come in further detail in regulation and guidance, or whether that will come before the bill finalises its passage through the Assembly. Clause 7, impartiality. There weren't a huge number of submissions on this. However, close association was raised as something that perhaps needed a clearer definition to people. And as per clause 2 of this, it might not be appropriate to insert a definition into the bill. However, I think the committee could ask for further details of what is meant by close association, just for its own benefit, which could then be included in the committee report. There were some concerns raised about religious affiliations and also bias in obstacles to impartiality. However, these weren't majority views. So I would suggest that we seek a further definition of close association to help the committee in its deliberations. Duration of appointment, clause 8. Strong support within the submissions for the safeguards as detailed within this clause. Again, and this comes up in a number of submissions, political interference is something that is cited really when there is any involvement of the department in either appointing people or having a say in it. So there are calls for an independent oversight of that process. I think that this is something, again, that perhaps might be outside the actual scope of the bill, but is something that perhaps the committee could recommend in its report.
So, not to open this up, but weren't we going to look at what other inquiries, like Muckamore, in terms of their process? So that might be something once we get that research back.
Yes, and also I've actually made contact with relevant officials at Muckamore, and we'll be getting further detail on that. So,
even RHI, because that was a full panel.
Yes, and I think also the COVID was more about modular approach, but yeah, so I have made contact with all of those. So I think that'll form part of our deliberations over the coming weeks. Okay. Where are we? Clause 9, assessors. Again, submissions were really that it needs to be a trauma-informed, survivor-sensitive experts to be included in the assessor cohort, and transparency in the roles. So again, I think committee could ask for more information on this and then could issue that as a recommendation within its report.
Because everybody doesn't want a capita.
Yes. No.
Everybody said what they're clear what they don't want.
Yeah.
Yes.
But that leaves it vague that it could be, in my opinion.
Well, okay. Yeah, that's clause 10, advisory panel, and I know that this is something which is the role of advisory panels has hit the news this week with another inquiry. Very strong support from all submissions on it being a survivor-led inquiry panel for the process of the inquiry itself. Also calls for the clear roles to be defined and for representation to be diverse when it comes to the advisory panel. Again, I think this is something that committee may want to look at in terms of its deliberations, and may want to consider a clearer definition of the role of the panel, not just its appointment. So we will move on. We now come into some more technical clauses. So again, there was mainly support for the Clause 11, suspension of the inquiry. Some respondents did raise concern about the risk of political misuse of the ability to suspend the inquiry. So again, I think committee would want to note that and then discuss that further, perhaps in its clause by clause. Clause 12, the end of the inquiry. Some stakeholders raised concern about a premature closure of the inquiry, although I have to say that wasn't a widespread concern. There was also requests for survivor consultation before the inquiry is published, and again would be something for the inquiry, I think, to decide for itself, and also potentially Assembly involvement as to whether the inquiry would report to the Assembly before it published.
That needs to be in the terms of reference.
Exactly. No, that's right. Clause 13, again, a fairly technical, and there were few comments on this clause. But again, the overriding theme is trauma-informed, flexible evidence gathering, and some stakeholders wish to underline the importance on accessibility and fairness in all procedures that the inquiry takes out, procedures the inquiry holds. Clause 14, public access. Again, support was shown for transparency, and again, this is something committee has already talked about and continues to talk about, survivor privacy protections and witness protections to be available and used as required during the inquiry. There were also a number of requests for guidelines on admittance and a refusal of admittance to hearings and inquiry proceedings. Again, I think that's something really for the inquiry to actually make within its guidance, not necessarily for the bill. However, obviously the committee could make a recommendation on that as part of its report. Clause 15 is the opposite of that, restriction of access. So respondents stated there should be a balance between both transparency but also protection for victims and survivors on this issue. And again, I know this is something that has been raised in committee before, and also there were concerns about, although there may be procedures to shield witnesses and victims and survivors within the inquiry process, stakeholders were very keen that those shielding processes weren't to be used for institutions. Yeah. And so that perhaps there is something to just clarify that there would only be certain groups that would be afforded those shielding processes. But again, I think that's something we could potentially seek further clarification on the department as that whether it plans to strengthen this clause to actually define who would be given the right for those shielding procedures and who wouldn't. So that's something again the committee can think about during deliberation. Clause 16, powers to require evidence. As you would suspect, very clear and strong support for the inquiry to have all relevant powers to compel evidence from any public body or otherwise where necessary for the inquiry to complete its investigations and conclusions. And again, that has come through in all three of the stakeholder events that we held. One specific area that, again, committee has touched on is the issue of cross-border production of evidence. And that was raised by a majority of respondents, and the bill as it's drafted now is silent on that. However, obviously the bill can only deal with its own jurisdiction. However, it may be worth if members want to seek further information from the department on their view on cross-border evidence.
Sure, I think we need to write at this stage. So I don't know if this has ever come up at an NSMC, but I think that this is where it needs to be. I mean, the Irish government, the last one, sealed the records. And I think we need to ask, can we just get an up-to-date position, particularly because a lot of these religious orders were all aimed and they're, and so I think at least we need to ask about that, particularly in relation to clause 16.
Yeah. Chair, members happy for us to do that. That's no problem. I know, certainly just as an aside, at the last North South Ministerial Council last week, the First Minister talked about discussions around this bill with the Republic of Ireland government. So obviously it is something that's on the agenda. I think generally. So clause 17, now moving on, privileged information. This is something that the committee have already touched on in terms of public interest immunity. I have to say there weren't a huge amount of submissions on this, but some did raise concerns about the misuse of public interest immunity. And again, committee have received advice on that and are due to receive further advice in the coming weeks. I would suggest that we note the legal advice received, and again that can form part of the deliberations, and we are due to get more advice on that on the 18th of November.
Go ahead,
as well.
please, Carol.
I'm just being honest, the legal advice I got was so sitting down the middle. It didn't say anything one way or other. I'm just being honest. I just found it very unhelpful. May factually be factually correct. It's not to say that what they produced wasn't good work. It just didn't provide any clarity, to be fair. So I do think we need to come back to this at a later stage, because if this had been in, for example, as part of Concora, then you can be rest assured that British national security would have been used not to give those victims access to the information that they need. And I can't imagine it being used here, but the fact that it's there is problematic.
Right. Yeah.
So we may need to come back to some of the concerns that were raised, because I'm not saying we need to take this out. I'm just saying we need further explanation about what tests are there that a PII would be used. Where's a public interest test in using a PII in an inquiry about a scandal? That's for us. We need to keep it right. And legal information is privileged, but this is a democratic public scrutiny bill. So I do think somewhere along the line we need to open that up a wee bit, if possible.
Certainly, Chair, I can look to request with the colleagues further clarity on that we could then use in the deliberations, certainly, if that's okay. We'll move on then. Clause 18, submissions of reports. Again, widespread view that reports must be thorough, survivor informed and lead to change, which sounds obvious, but many stakeholders wanted that. And there was also some support for interim reports. And this is something that isn't currently included as part of the terms of reference. So again, perhaps to suggest members may wish to consider writing to TEO just to find out whether it has considered interim reports as part of this clause or not, because currently it is silent on that.
Sorry, Chair, if we went a modular approach, would there not be a report at the end of each module?
Well, again, because we don't know what the
approach... Okay,
yes,
fair enough.
So it ties in with that, which I'll come to in a bit, but yes, that's right. So,
Chair, Clerk, just before you go on then, so obviously we've got quite a lot of queries to go back to the Executive Office. So at what point, will we receive that in written form, or will we as a committee have another opportunity to test some of these issues? Both.
Yes.
Okay, in terms of them coming back to committee.
Yeah.
Before we go into formal deliberation.
So the officials can be part of the deliberations before we go into the clause by clause. So it'll be that point that we will try and get all of the queries sorted. Okay. So we were up to clause 19, publications of reports. More of a technical clause this, but again, widespread view that redactions must be minimal and justified. And there was also the theme of political interference on there. But I think that's something perhaps for the clause by clause. Clause 20, very technical, laying the reports before the Assembly. That's something that would be part of the bill anyway. And it was welcomed that publications are required to be laid and therefore in the public domain. Clause 21, witness expenses. Again, this is something that committee have engaged with various stakeholders in oral evidence. Widespread support for legal and financial support for witnesses to the inquiry, especially those from a victor and survivor cohort. There was requests for clarity and fairness in expenses on offer. That's something that I think we have gone to the department on anyway to get clarity around expenses, so I think that will come back to us. It may be that further guidance is required on that. Clause 22, again, technical in nature. That's around inquiry expenses, and there were a couple of concerns raised about Executive Office withholding funds for the inquiry, but I have to say that wasn't a widespread view, and really that this clause just allows for the inquiry to be funded more than anything else. Clause 23, offences, widespread and strong support for penalties against obstruction of the work of the inquiry. And to be honest, I don't think we need to say much more on that. Clause 24, again, High Court enforcement, very strong support for enforcement powers. And I have to say that, as I've said there in the brief, this clause, by those that responded, see it as essential for accountability, that there is enforcement there. So again, really for members to note. Clause 25 is technical and comes from the Inquiries Bill, but there were some mixed views on this. There is widespread support for protection of staff on the inquiry. However, there is some concern about a lack of accountability for other participants in the process. Again, I think that's something that we can come back to in deliberations. Clause 26, this is one that has come up in committee, and it was clear that 14 days as the timescale for application for a judicial review, many stakeholders thought that was just too short. There were several requests by respondents to extend this to assist trauma-informed flexibility to be shown. Remember, we've already requested the department's view on the 14-day time limit and also for the rationale behind that. And so we haven't yet received a response, but obviously that will come back to us. Clause 27 is rules. Widespread and strong support for anonymity of witnesses who are representing the victims and survivor community if required. Strong support, again, for full document access. Also some requests for further powers for survivor access to records. Again, this is something that we will keep coming back to in terms of access to records and anonymity, but really for the committee to note for now. And again, if there is thought on committee amendment for that, then we just need to think about the scope of the bill. Clause 28 is a technical one, consequential amendments, and there is support for oversight by the Children's Commissioner where necessary. Clause 29, again, is fairly technical around interpretation, and there were just a number of requests for a broader definition of this. But again, we can note that and come back to that in deliberations.
Sorry, I hadn't, maybe in reading this, I hadn't picked up on that before in terms of, can we ask the department why they've gone for the Commissioner for Children and Young People as opposed to the Commissioner for Older Persons, given the profile of the people who...
Yeah.
Just as a query, sorry. Yeah.
Or both.
Yeah.
Or both?
Yes.
No,
Yeah.
But it's just, I hadn't picked up on that one before.
Yeah, that's fine. So that really ends part one of the bill in terms of the building of the inquiry. The second area then is obviously the building of the redress service for the acknowledgement payment and the first redress payment. So clause 30 is the start of that, and there is unanimous support amongst respondents for establishing a dedicated redress service. Again, many submissions emphasise the need for it to be trauma-informed, accessible and survivor-focused. And again, I think that came through very strongly at our stakeholder events. There were concerns about bureaucracy and therefore re-traumatisation of people having to go through a process again. Although I have to say it wasn't a widespread view in terms of the call for evidence, but again, call for guidelines and transparency and adequate resources. Again, at this stage, I think for members to note that.
Yeah.
I think certainly there's stuff came up today around the eligible. I think even just some of the language is very, it's difficult for some people to understand what's actually being said. So
members will not be surprised to know that clause 31 had the most response from all of the clauses from the written evidence. Obviously, very widespread and strong support, strong opposition, to the £10,000 standard payment. Many suggested a range between £12,500 and £15,000 or even more. There isn't, having looked through all of them, a single value that sort of comes to the fore, but certainly between the 12.5 and the 15 appears to be.
Richard, see at the end of HIA recommendations, it talked about the payment for any future issues to be in line with inflation. I mean, so how long ago did HIA finish? 2016, was it?
So the inquiry report was published in January 2016. 17, sorry.
17, yeah.
So if you take that as the starting point, but then again the legislation for the redress scheme, I think that was 2020. So it really, I think we'll have to come up with some transparent rationale for why we would be doing something. But there are a number of different points, isn't there? And then also by the time this gets royal assent as well, you know, it'll be 6 months hence from here as well. So they take that in.
But potentially by the time the redress service is actually built and running, you're looking at more than 12 months from even royal assent, I think perhaps. So just to move on there, again, very similar strong opposition to the amount of £2,000, and again those criticisms have been rehearsed throughout all of the stakeholder events. There was unanimous criticism of a posthumous date of the 29th of September 2011. Views vary in relation to an alternative date, but I have to say that there is unanimous disagreement with the current approach. I think that is clear. Some submissions call, just in other parts of that clause, for the inclusion of other siblings, again for birth fathers and for those affected outside of listed institutions. There were a small number of requests for a harm-based approach rather than admittedly based eligibility, but obviously this particular part of the scheme is acknowledgement. The harm-based comes in the next. So, yeah, I thought just for transparency more, just to say that there were a number of people who said that, but that will be the second piece of legislation that comes forward on that.
Just on that, what came through very strongly this morning wasn't about the place or the institution. It was about the harm that had been caused and the trauma. And that's something the committee, I don't know how you do that, because we have focused on location as opposed to actually the trauma that has been caused. But that's something that came across very, very strongly time and time again at the round table this morning.
Thanks, Chair. Again, and I think that is what really the inquiry is there to do, to try and get to the bottom of that harm. Clause 32, moving on, application timeframe. Again, something that the committee have already looked at is there were mixed views on a 3-year window for an application for the first redress. Many respondents preferred 5 years or more. There were also therefore concerns, and again this came up this morning, about elderly applicants, those who are not in this jurisdiction, and those who are what's called late discovery adoptees as well.
Just something that's occurred to me, if we do go for the 5 years and it looks likely that it will be 3 years extended to 5, will that push back the independent payment or individual payment a further 2 years?
I think so. I think
I'm not sure.
I think it was going to come after the inquiry, the second redress scheme, so I don't think it'll have that much of an influence in terms of this.
No, Chair, I think the inquiry, the conclusion of the inquiry will then inform the process for the harm-based approach, whereas this is almost a standalone acknowledgement payment. Clause 33, application for payments. There was some criticism from stakeholders of judicial-only panels, and again, a more widespread preference for, again, trauma-informed multidisciplinary panels. A number of submissions called for a simplified, accessible application process. Obviously, the application process itself will come through in regulation following the bill becoming an act. Also, a lot of emphasis stated on compassionate handling and maintaining survivor trust during the application process. So, members may wish to seek further information from the department on whether there has been any thought about the application process itself and how far down the line the department may be on that. Although I think it isn't something that would be on the face of the bill. It is something that will come through in guidance and regulations.
But again, I think it's something we could be commenting on in terms of the committee report. So I think it's something that we do need to be aware of in terms of the thinking of the department.
Absolutely.
Yeah, because we had that lady who raised the issue. She's a cancer diagnosis.
Yes. And in the bill there is people with life-limiting conditions will get preference. That's in the bill as stands. Or I think...
terminally ill.
Terminally ill, I'm so sorry, yes, terminally ill. So yes, I don't know whether that individual would qualify for that or not, but there we are. Okay. Clause 34, priority of application. Sorry, just coming on to that. Obviously, widespread support for the bill's proposal to prioritise terminally ill applicants. Also, some suggestions to broaden that criteria to include serious health conditions, mental health conditions, and elderly survivors as well.
Yeah.
Again, members may wish to seek the department's view on broadening the criteria for priority applications.
Yeah, Chair, I think that's there's two aspects to this. One is I think widening it to, as you said, serious illness and other conditions. And if you're going to prioritise terminally ill applicants, what is the definition of a terminally ill applicant? That's a DHSS determination, which I think in this case, in the last 6 months of your life, this might not be your highest priority. So I think it has to be a wider range than that.
100%.
Okay.
Clause 35, the power to require further information, again touched upon at all of the stakeholder events, widespread and strong support for the powers within the bill to compel evidence from institutions, religious orders and government bodies. Respondents placed emphasis on privacy safeguards, making sure that trauma-informed practices and support for survivors were used by the inquiry during this. Again, I think that's a very clear and strong support on all of the oral evidence we've received as well on that. Clause 36, the power to disclose information. There was overriding support for this. However, there were concerns about privacy issues, especially for birth mothers, although I have to say that wasn't a widespread view. There were also some requests for informed consent for anonymous applications and obviously for data protection in terms of applications as well. Again, I think members to discuss further in their deliberations. Clause 37, which is payments, very strong support for it to be lump sum payments, so a single payment. And also, again, unanimous agreement that payments do not affect benefits, legal aid, care costs, and very importantly, in every jurisdiction. That was a key theme coming through, not just in Northern Ireland. Again, members to note, I think, during deliberations. However, it may be worth members seeking departmental assurances about future payments being exempt from tax, because obviously this only speaks on this redress acknowledgement payment. It could be, the committee talked the other week about perhaps bridging that takes the legislation to the next stage in terms of saying you must make sure that those are also exempt from tax or welfare payments. Something to think about.
Certainly the tax is an issue that's come up, not just benefits.
Yeah, tax as well, absolutely, yes. Clause 38, we're nearly there. Right to appeal. Again, widespread concern, and again, this is something that's come up in committee, that the 30-day appeal window is too short. Suggestions range an increase from either 60 to 90 days, and again, flexibility built into those windows for trauma, illness, or support needs. Some submissions mentioned should there be a prescription for legal assistance on that right to appeal. Members may wish to seek the department's view on extending the appeal period, if members are keen to do that. Clause 39, advice and assistance. Much support for financial advice and legal support being provided as per the bill that's drafted. Some stakeholders wish to see independent advocates and trauma-informed advocates and survivor involvement in actions resulting from this clause, but fundamentally this clause was supported by the majority of respondents. Clause 40, restriction orders, again, support from stakeholders for protecting survivor privacy. Some concerns about indefinite restrictions, and again, potential misuse to shield institutions. So this goes back to the earlier clause that we were talking about. Again, I think something to come through in deliberations. Clause 41, widespread support, again, for appointing advisors with lived experience and specialist knowledge. Some respondents called for clear criteria and transparency for this application process. Clause 42, regulations. There is definite stated recognition for the need of flexibility for terms in this clause, but some concern about discretion are also raised by a smaller number of sufficient. There is clear emphasis on, again, survivor consultation, clear guidance and compassionate rules. It may be that the committee might wish to ask the department whether they have any thoughts on the guidance that might come through on this at this stage. Clause 43 is very technical, application to the Crown. There was a small number of submissions, concerns over exemptions for UK, Scottish and Welsh governments. However, I think this is just purely a technical clause to allow the legal requirement for the redress system. Clause 44, again, is technical in nature, supplementary provisions. A small number of submissions on this clause. Support for flexibility was noted, but again, a clear emphasis on transparency. Clause 45, the general interpretations of those who submitted responses to this clause. There is clear support for definitions and accessible formats, including inclusive formats for those with disabilities or literary challenges. Again, this may be something members may wish to consider during deliberations. Clause 46, commencement. Only a single submission raised a concern over delays in implementing Part 2. However, there were a number of requests, and this is an interesting one, of timelines and contingency plans if the executive were to collapse before the commencement of the inquiry. And it required TEO or FMDFM to actually, is there anything that...
Is there a mechanism?
That would actually allow things to go forward? So, again, something members could ask the department, and to be honest, something that hadn't come up up until that point.
Very, very valid.
But I think it is a valid point. A couple more there. Just to ask the department to provide an updated timeline on commencement of inquiry and also on contingency plans should the executive not be in place. And then finally, clause 47, the short title. A lot of mixed views actually on the title of the bill. Many felt that it's too narrow. It excludes private homes, pathways, systemic practices. More individual suggestions for an inclusive title that also reflected perhaps forced family separation and adoptive systems. But again, I think that's something for members to note during deliberations.
We can come back to that.
And at that point, I'll stop speaking.
Okay, so there was quite a lot of, obviously in our packs we got the suggested actions, and a few more have been noted. I wonder maybe after the meeting could you circulate that list and we can maybe sign it off on by email, is that?
Yep, if members are happy to do that, we can...
The other...
It's just while we were going through, there were a few extra ones that were...
In the clerk's brief, so there are sort of proposed actions, 75 to 84, but there are a number of other actions now, so I can add those in and recirculate, and then we can go from there.
Okay, thank you.
Chair.
Sorry, hold on a second. I'm going to bring Timothy, the Deputy Chair, and then Sinead will bring you in after, okay? Sorry, I didn't see it. Go ahead, Timothy, please.
Just something that came up very strongly this morning. Clause 31, I suppose, would deal with it when it was talking about entitlement to a payment. Strong support for non-financial help as well. And I'm just struggling to think where in the bill. And what came across this morning was, yes, there's already mechanisms through VSAs, whereas those with the lived experience at the table this morning were wanting that when there isn't a sense of entitlement to the payment, there should be something coordinated with that of direct help coming in a centralised location, that they don't have to go to VSS, which is discretionary, whereas if somebody is entitled to an acknowledgement payment, surely that should then open a door for them to get help following that, and it'd be lifelong help, not just for a number of years. That was something that came across strongly this morning. I don't know where you put it in, because obviously clause 31 is talking about payment, but there is a big what would you say, focus upon from certain individuals. This isn't about money. This is about getting the physical, the mental help that potentially they haven't had. When they're getting an entitlement payment, they believe there should also be the services to wrap around them as they move forward, because obviously this is going to be traumatic. When we have the inquiry, there's a lot of things that are going to come up, and I believe that's something we should be looking at.
Certainly, I think that's maybe for the committee report, but well noted. Go ahead, please, Deputy Chair.
I was just briefly, is this maybe the time to raise the issue of the gang rape inquiry in England, which appears to have gone off the rails somewhat? It maybe goes also to the Muckamore inquiry as well. Can we just check what the learning points are from that current situation in England, particularly as it circulates around the independent panel role.
Yeah.
Yes, Chair, the Clause 10
Yes.
advisory panel, very much in the news at the moment. I've already approached Muckamore, and I'll see whether, I'll have a look to see whether there's anything else we can gain on that. But yes.
If we
yes.
keep an eye on what's happening in England, that would be useful.
Certainly. And sorry, Chair, also just on Timothy's point, I think perhaps next week, hopefully we will get the Hansard of this morning's evidence from the stakeholder events, and that may help to clarify or sort of concentrate exactly what people were saying this morning about that, which we can then bring back to committee. Sorry.
Sinead, go ahead, please.
I was going to say exactly what Stuart had said about the inquiry in England. I think, we just need to keep a close eye on that to make sure that we don't fall into some of the problems that they are currently experiencing. And then the other thing, just finally to say, that is a brilliant piece of work. That document has been really, really helpful. So thank you to the team for bringing that forward and going through in such a way, because it brings a lot of clarity to a lot of the evidence that we've received to date. Thank you.
Okay, thank you. So, as I we've agreed that you're going to circulate, but I think maybe even just as we're moving into recess and then we'll be back and we'll be doing our deliberations, do you want to speak to some of the work that Stephen Orme is doing, or Bill's clerk?
Yes, so the Stephen Orme is the bill clerk for this particular bill, and Stephen's actually on paternity leave at the minute, having had a baby boy 10 days ago, which is great. Sam, his son. Stephen has already started to formulate a number of potential areas for amendment, which again will crystallise more in the deliberation section. Yes. But behind the scenes, there's been quite a lot of work done on that in terms of areas that had come up over the last 23 oral sessions that we've had in terms of evidence, areas that keep on cropping up, and it's quite clear the clauses where perhaps that would be. So again, that's something that I think from the 12th onwards will be coming to committee in with much more detail.
But I think it's useful to get that, especially for those people who've been watching this intently,
yes.
that these are issues that are going on, or work that's going on behind the scenes, so it's not just consequential. So just want to give reassurance that we're trying our best to move this forward. Go ahead, please, Timothy.
Yeah, so Stephen is obviously watching the evidence sessions and bringing them forward as potential ideas for committee. Is the department doing something similar? What's their status in all this?
Yes, Chair. The department, I'm sure, are watching intently all of the evidence sessions, and I know that obviously from those sessions anyway, there are lots of queries that we are sending to the department. They will be working on those and coming back to us. They have started to come back to us on some of those. Again, we will get all of those together, and they will form part of the deliberations. But certainly, the conversations that I've had with officials in the department is that they are intently watching the evidence that the committee have been gathering over the last number of months. Absolutely. Yeah.
Would it be appropriate for you to comment on that from the gallery? Do you want to come and take a seat, please?
Thank you, Chair.
On cue. Very good.
So, yes, certainly we have been paying very close attention to committee's deliberations and all the evidence sessions you've been having. And obviously, from listening to you, we've been able to come up with noticing where we think the committee might like to amend the bill. And then we're taking legal advice on those options and preparing advice for ministers to consider, the pros and cons of each of those options based on the legal advice, and preparing draft instructions so that where ministers would be supportive of any of the potential committee amendments, we would intend to share with committee, what those amendments would look like, with an important caveat: if they are substantive policy changes, they would be subject to executive agreement. But so that work is certainly ongoing.
I'm not going to open it up for questions, but thank you for that.
You're
put you
very
on the
welcome.
spot, because the clerk has confirmed that you will be coming back in an official capacity as part of our deliberations.
Absolutely.
Okay, thank you so much.
You're welcome.
Thank you. Okay, members, anything else on that before we move on? No. Okay. Okay.
I just say, back what Sinead said too, well done, the team.
Yeah, pack's great.
Super piece of work, thank you.
Very much.
Okay, members, so we're going to move. Okay, so we're going to seek our committee agreement to go into closed session for the next item.
Yes.
Okay. Members, we've just gone into back into open session. We had a briefing there from the TU officials in relation to the review of the Commissioner's Office and the independent review of the historical institutional abuse redress process. So I don't think there were any actions from it, Clerk.
No, Chair, none that I was.
But just to say that the Commissioner will be coming to committee on the 19th of November, so we can pick that up, but that will be an open session. Okay, members, just moving on then to correspondence. You'll find this on pages.
Chair.
Sorry, go ahead please, Sinead. Thank you.
Chair, I probably you explained to the committee before I joined at the very beginning. Item 7 has been removed from the agenda today for any particular reason.
Okay, I'll maybe ask the clerk just to brief on that.
Yes, thanks, Chair. Yes, it became clear that officials were unable to provide a written report or briefing on that item, and so following discussions with the department, there will be a more fuller report coming in the next few weeks that currently has not received executive sign-off. So the view was, I spoke to the Chair and Deputy Chair, that actually it might be more prudent to just postpone that until they have that report and committee can then see it, and that will then give tangible delivery data that you can question on, rather than at the minute them really not providing anything and just going off what's in the programme for government. So we look to postpone that until perhaps next month, or it might be into the new year.
So
That's really concerning, and I suppose fundamentally that's why we wanted to hear evidence from the departmental officials around delivery. There's a view widespread in the public about the lack of delivery within the programme for government, and for officials not to be able to put forward a document that we can question is symptomatic of just what is wrong. So really, really disappointed, and I think that needs to go on the record.
thank you, Sinead. So whenever this was brought to my attention yesterday, when I had the pre-brief with the clerk and the assistant clerk yesterday afternoon, because there is no point in us having the programme for government, that was the submission that we received. We need to be able to scrutinise it. There was a potential that we would have been given the speaking notes in advance, but again, I was very conscious that a lot of the members here today were at the roundtable event. So even if we had received it at 11 o'clock, for example, the speaking notes, we still wouldn't have had an opportunity even to read through those. So I think quite early on I was of the opinion that we shouldn't have gone ahead today, and then we brought the deputy chair in as well, and then you've been liaising with the DALO, but there's no point. We have to be able to do our job as a scrutiny committee, and I don't think it's a reflection on the departmental officials. I think it's the fact that they couldn't get a sign-off on a report from the First Minister and Deputy First Minister. So we will have that this session in a few weeks, but it will be whenever we as a committee are satisfied that the information in front of us will allow us to do our job. Go ahead please, Timothy.
Yeah, it's certainly disappointing. PFG talks about doing what matters most. A lot of people like myself are very sceptical. Even within the programme for government, there is no commitments on a lot of the stuff, and any of the things there is commitments in, they seem to be failing miserably. Deeply disappointed that it was 12 minutes past 1. We got the email today to say they weren't coming. A lot of preparation has went in to try and uncover and try and probe and come up with questions to ask them. So I do think it's unfair that it was so late in the day that this had been cancelled. If it required executive approval, the entire executive, that would have been last Thursday that it met, and we should have known, or they should have informed us at least last Thursday. Listen, we do not have an agreed update of where we're at, because today we were hoping to ask questions, and yes, I know this is TEO office, but they oversee all this. So regarding the policing numbers, the money that goes with that, health, the waiting times, and once again we've been left disappointed that we're not getting the information and we're being treated as an afterthought. I think it really speaks to how they treat and how they look at their scrutiny committee. That, you know, within a couple of days of the committee meeting, we haven't got any concrete or an agreed place. I think it's per reflection the executive, per reflection the First and Deputy First Minister, and it's just a continuation of my time in Stormont of how we're being treated.
Well, I think there was a bit of context this morning from, I think, the clerk. The email might have come out a little bit earlier, but obviously we had such a busy morning, as you know, at the Europa. You were probably there from about 9 until at least 1 o'clock. So you probably sent that email from your car before you set off.
The first thing I did when I got back into the office.
And I'm not blaming the officials in here, but it should have been quite clear after the executive meeting last Wednesday, Thursday, whenever they have them, that they don't have an agreed position, an agreed update of something to present to committee.
Well, I know that you will be trying to get that rescheduled as
soon as we can. Yeah.
Okay, happy to move on. Okay, members, so we're going to correspondence now. So I'm going to refer you to pages 360 to 367 of your pack for the summary of committee correspondence, and I'm going to draw your attention to a number of items. So pages 393 to 400 of your pack, just to advise that the Communities Committee has responded to the committee's correspondence for the 11th of September regarding the inquiry Mother and Baby Institutions, Magdalene, Laundries and Workhouses and Redress Scheme Bill. Just to advise that the Communities Committee has identified a number of areas which fall within or are very closely related to the remit of the Department for Communities. The following are areas of potential overlap and scrutiny interest, informed by the areas of scrutiny and issues which most frequently come before the Communities Committee. Just going to run through those now. Interaction with social security and benefits legislation and disregards. Provision of advice, assistance and financial guidance to survivors. Equality, inclusion and ongoing support for survivors, archival access and preservation and historical records management, community input, memorialisation and legacy programmes, and potential ongoing financial and administrative implications for the Department for Communities. So I'm just going to seek your agreement to note this item of correspondence and to write the Department outlining their concerns and consideration, ask the Executive Office to respond to these concerns and outline what, if any, engagement has taken place with DFC on this bill. And that's maybe something you want to raise, picking up from earlier.
Yeah, so I mean, just in terms of the crossover, so this is an Executive Office bill, but there will be other implications. For example, communities have very helpfully pointed, the committee has very helpfully pointed out where there's a crossover for them. There is definitely a crossover with health in terms of the records, and I've raised this before in terms of adoptees and their birth certificates, which is the Department for Finance. It still says adopted on it. They're treated and processed differently, and this is even adults in their 70s are saying that there's no need for it. So I would certainly like to see, particularly with the records, and again, what we can do with TEO in terms of covering the costs as part of the inquiry.
Yeah, that sort of reverts us back to the conversation we had earlier on, and the actions will come from that in terms of writing. Yeah.
So are we agreement then to write to the Executive Office with those concerns and include that aspect around the financial?
Yes.
Okay, thank you. Okay, pages 404 to 406 of your pack, members, just to advise that the Department has responded to the Committee's correspondence of the 23rd of September in relation to the Dilapidation Bill and the Insolvency Amendment Bill. I just to advise that there are no implications for TEO in respect of each bill. So I'm just asking your agreement to note this item of correspondence and agree to write to both the Committee for the Economy and the Committee for Agriculture, outlining the nil return from the committee. Agreed? Thank you. So individuals, so this is the Castle Newton Cunningham Children's Home.
Yeah.
I'm going to refer you to pages 407 to 410 of your pack, and just to advise that the committee has received correspondence from an individual in relation to the bill, including an institution not listed within the bill, anatomical issues and standard and individual assessments, and the access to records, adoption practice steering group. An issue also relates to the the previous committee in which no further action was taken. And if people want to discuss this correspondence further regarding the content and the individual, we will have to move into closed session. No. So, okay, so I'm going to ask your agreement to note this item of correspondence and agree to respond to the individual regarding the second query, and any issues relating to the update on the memorialisation plans should be referred to Queen's University in the first instance. But I do think there are items within that which should form part of our deliberation for the bill itself.
Yeah.
So it was a useful piece of correspondence, but in terms of actions, in the immediate term, that will be that. Okay.
And it will be included within the bill pack.
Evidence.
Yeah.
Okay, thank you.
Yeah.
Okay, members, page 444 of your pack, and just to advise that the committee has received correspondence from an individual regarding clarification on the scope of clause 3D, and that's the inclusion of adoption agencies and coercive adoption practices. And just to seek your agreement to note this item and to move to agree to move the correspondence. Sorry, to forward the correspondence to you to ask them to address the concerns outlined in the correspondence. I'm wondering, is that in terms of that list of queries we are sending to the Executive Office today, I wonder, should we just add that as this query in terms of clause 3D to that?
That's fine.
That'd probably be easier, would it then?
That's okay.
And then we can then forward that section to this individual.
Yes.
Agreed? Okay, so members, I'm going to refer you to pages 561 to 564 of your package, just to advise that the Department has responded to the Committee's correspondence of 2nd October in relation to an update on payments made by religious institutions under the Historical Institutional Abuse Redress Scheme, following the HIA Redress Board's closure to applications on the 2nd of April this year. Just to advise that to date, TO has indicated that payments have been received from the Good Shepherd Sisters, Bernardos, the De La Salle Order and the Diocese, can you say that, of Down O'Connor in respect of the De La Salaran.
La Salle.
Oh, sorry. Oh, these words. The two words emerged. De La Salle Run Homes. Engagement with these institutions is ongoing to finalise their contributions, and details of the amounts received will be published once the process is complete. So, seek your agreement to note this item of correspondence and agree to write the Department to ask that the committee is kept informed of the details surrounding payments made by the religious orders under the HIA Redress Scheme once the process is complete. I am concerned that this process is ongoing. And when is the process complete, and when do they draw a line on it? I don't think that this response is good enough.
No, neither do I, to be frank. I just think it's this open-ended negotiation. Yeah. We'll get back to you when we find out. Yeah. I mean, we're now going to do a clause by clause at our next meeting. Yeah. And I would wish to have more clarification on what that actually means, because that's saying a lot, but telling us nothing.
Exactly.
I have a further concern, particularly around the words of, I think, does it say somewhere, when these negotiations are concluded? Yeah. Sorry, we haven't had the public inquiry. And the conclusion of the public inquiry might be 10 times the capacity of what might have been concluded. And I do not, under any circumstances, I want to put down a very clear marker now, it would be completely and utterly wrong of the Executive Office to reach any binding agreement with any of these organisations in advance of the inquiry.
This is HIA?
Sorry,
this is HIA, it's not Mother and Baby Homes?
It's not Mother and Baby Homes.
So this is HIA, but our same scepticism applies, because we had someone in before who the interlocutor, intermediate, whatever. Yeah, and that process was going on as well. So this is HIA, but I also think we need to put the marker down that Stuart's mentioned, that it will be for the public inquiry to determine but the department still need to keep pushing, because in my opinion, Stuart, if the department give up, by the time it goes to inquiry, it almost lets the religious orders and the others, the bodies, all off the hook.
Yeah.
That's
my fear.
Agree with you.
I wonder, so can we invite the independent facilitator back?
Yeah.
I don't think.
The update is on what he's done since the last time he was here.
Yeah. I don't think they can hide behind this.
This is HIA.
No, the last time he was here, people didn't know, was he working for the Executive Office or was he working on behalf
of the
institutions? Because the lackadaisical approach of delicate stage we're at, whereas we need somebody that's going to go in, thump the table and get justice for people and get the money out of the institutions that they should be paying.
Well, I thought he worked for the Executive. They procured him.
In title, but when you heard the response in the presentation, it made some of us wonder.
Okay. Okay, so maybe we could look at that?
Yes,
Okay.
no problem.
Okay, thank you. So, where am I now? Okay, so I'm just going to ask the clerk to read some other piece of correspondence into the record. Thank you.
Thank you, Chair. Items 9.2 to 9.3 are the Hansard reports from recent evidence sessions with Dublin City University, Queen's University and the PSNI from the meeting of the 8th of October. Item 9.4 is a response from the Committee for Health to the Committee's correspondence of the 27th of June regarding views from statutory committees on the bill, and the Committee for Health have replied with a nil return. 9.6, response from the Economy Committee to the Committee's correspondence of the 27th of June regarding views on the bill, and the Economy Committee have also replied with a nil return. Item 9.8 is an individual's correspondence relating to the urgent need to address parallel failures in family court handlings of domestic abuse. Just to advise members that the committee was actually CC'd into this correspondence, which was addressed to Doug Beattie, MLA.
Doug Beattie, that's right, yeah.
Therefore, no further action for the committee is required at this stage.
Sorry, Chair, can I just speak to that piece of correspondence? And the reason that probably that was CC'd into this committee is I think that we really need as a committee to reflect on just some of the systems that are happening in the family court as it relates to ending violence against women and girls. And that was what was so important in relation to the content of that letter, because the purpose, what is happening in the family courts is actually prolonging violence against women and girls. And I think that we as a committee would have a duty of care to kind of look at just what is happening in those areas and how domestic abuse, for example, is not been taken into consideration in the family courts when perpetrators of that abuse, and some of it is so severe that it's rape and paedophilia, and yet access to children are being given, and how we as a society can change that culture in ending violence against women and girls. And that's why I think it's really interesting to look at that letter, and also even to look at what's happening in the reform that is happening in the UK today, actually, where pro-contact presumption has been looked at in their family court system, and how we need to really look at that if we're serious about ending violence against women and girls. And that's why I think that piece of that letter that was sent by Jenny Wilson is really important, because it highlights that. And I think that we as a committee, if we're going to be scrutinise just exactly what is happening in our strategy, how we have to work with the Justice Department in and around that as well.
Okay, so I was just checking there the forward work programme. I think that there's a briefing scheduled from department officials on the end of violence against women and girls on the 10th of December. Now that feels like a long way off, but I wonder, in the interim, should we maybe write and ask that we find out what they're actually doing in this space around the speeding up of justice?
To report on the 10th.
Yes, to report it. Is that okay, Sinead?
Yeah, and then even just in terms of, like, I mean, I'm in the family court at least twice a month. You're not allowed in the court, you just accompany someone. But when it comes to non-molestation orders, they're usually got, particularly if the police are involved. But when you go back 6 weeks later, it's a whole adversarial system. And I know it's probably something more to do with the Justice Bill. But I do think, in terms of the Law Society, we had them up last week, or was it last week, the week before, 2 weeks ago, just to ask them about this, because, I mean, I'm hearing frustration from solicitors, particularly around the impact this is having. And then the other end is if contact is awarded, there aren't enough social workers to follow up some of the conditions put down by the courts. So unless it's done through a supervised contact, then it's just causing a lot of anxiety. Now, I know it's slightly outside this, but when we are talking about violence against women and girls, Sinead's right. We need to consider all aspects.
I think it allows us, as she has said in her letter, to effectively normalise abuse and coercive control, because it's actually ignored in the legal proceedings. And it's really, really serious at this stage. I've heard a few very a number of horrific stories in relation to it, and it for us. As if we're prioritising this within the programme for government as one of the flagship programmes, then it's certainly we really need to get down to the nitty-gritty where it is actually occurring and how we can change it and stop it.
Thank you, Sinead. Okay, thank you, Claire.
That's no problem. We'll feed that back to officials in preparation for the 10th. And that there. So just moving on, Chair. Item, where am I? 9.10 is a copy of correspondence from the Committee for Communities to TEO regarding the PFG target to end poverty. Just for the committee to note, items 9, 11 and 9.12 are the Hansard reports from the committee's meeting on the 8th of October from KRW Law, the Law Society and Phoenix Law, and then also the Truth Recovery Independent Panel. Item 9.13, again, individual correspondence, and this is around the integration of family court domestic abuse within the Ending Violence Against Women and Girls strategy. And again, just to note that members were, that the committee was CC'd into this correspondence, which was addressed to Junior Minister Bunting. Therefore, I'd suggested no further action required at this stage, but I realise it links back to the previous piece of correspondence as well. Item 9.14 is individual correspondence, which is further information in relation to the bill, in relation to private nursing homes and birth fathers, and again this will be added to the bill pack. Item 9.16, individual correspondence, which provides information on the Australian government apology of 2013. And again, this is in relation to the bill scrutiny.
Just on that, I thought that was a really powerful piece of work. Did people read it? I just thought it was excellent. So yeah, I think that's maybe something we need to sort of capitalise a wee bit more on.
Item 9.17, correspondence from the Department annual report and financial statements for the Commissioner for Victims and Survivors for the year ending 31st of March 2025. Members are advised that the new Commissioner for Victims and Survivors has been invited to brief the committee in early 2026. We don't have a date for that yet. Item 9.18 is a departmental release. First Minister unveils new public artwork celebrating City of Peace. Item 9.19, individual correspondence. The committee has been CC'd into correspondence sent to Mr Gavin Robinson MP regarding the removal of a British citizen for Northern Ireland. I suggest that there's no action for the committee to take on that at this stage.
Nick, just on that, and I don't want to mention the name of the individual involved, but it does mention the PSNI and Redress housing. So to me, it should have been sent to Justice and Communities.
Yeah.
And I think we should send it on to them.
I think we would just need to get permission from the individual for that to happen, but we can do that. Communities and Justice. No problem. Okay, thank you. Item 9.20, individual correspondence regarding information on unmarked burials in private and institutional cemeteries in Ireland. Item 9.21 from the Department, Ending Violence Against Women and Girls bi-monthly e-zine. And just so members note, this is the first edition of an e-zine update from the EVAWG programme, which will be released bi-monthly. Item 9.22 is a departmental news release on ministers showing support for those affected by baby loss. Item 9.25, the Maze Long Kesh Development Corporation Annual Report and Accounts for 24-25. This has been added to members' papers for the committee visit to MLKDC, which will happen in 2 weeks' time. Item 9.25, individual correspondence, again, further information following discussion at one of the stakeholder roundtable events from the 15th of October, so therefore in relation to the bill. Item 9.26, response from the Department to the Committee's correspondence of the 12th of September, asking the Department what specific activities, including timescales on delivery, are being funded by the Local Change Fund within council areas. Item 9.27, individual correspondence providing further information relating to the bill and Section 102 of the Adoption and Children's Act NI 2022. Item 9.28, individual correspondence, again further information relating to the bill and access to records and equivalence of rights. Members should be advised that all correspondence relating to the bill in this correspondence table will be found in the bill pack under other papers, so we will collate everything there. Item 9.29 is an invitation from Nikki, invitation to World Children's Day, showcasing participation with children and young people in Northern Ireland. Any member who wishes to attend should register in the link provided within the invitation. Item 9.30 is a departmental news release, Good Relations Indicators 2024 report. Item 9.31, individual correspondence. This is correspondence from an individual regarding unlawful refusal, obstruction concerns and Section 77 notice. Just to advise members that this committee was CC'd into this correspondence, which was addressed to TEO. Therefore, I suggest no further action is required at this stage. And finally, item 9.31 is a departmental news release. Ministers launch community-led review on violence against women and girls in rural areas.
Okay. Anybody want to go ahead, please?
Taking you back to 9.14, it was the individual that had submitted evidence. I just would like to read out regarding the birth fathers, because this is something that we heard when you were taking us through the written evidence. A number of people read, but it's something that didn't come across very strong in the evidence sessions that we had in the room. So while many accounts of birth fathers involve experiences of abandonment, denial of responsibility or even mistreatment, it's important to acknowledge that not all cases fit this pattern. In some instances, including our own, birth fathers were themselves victims of coercion, pressure or exclusion. Some were denied information, misled about their rights, or prevented from having any involvement in decisions concerning their children's future. Like birth mothers, these men were ultimately separated from their children, often without consent or understanding, and many endured years of grief and loss akin to bereavement. So I think it was important just to read that out, because that's something that none of the panels really articulated. And it goes on to talk about private nursing homes, something that has been very, very strong coming through. And the last one, when it talked about state social workers, that's something that also came through strongly this morning at my table. I thought it was a very good letter, well set out, and you have said it will be part of the bundle.
Yeah, that will be contained within the bill pack that we issue on a weekly basis.
Yeah.
Okay,
Just
thank you.
that, Chair, there was a birth mother present in Dungannon last week, and the role of the father was very much and very strongly highlighted there. Again, a not dissimilar story where the father was forcibly removed from the circumstances, but is back and was back and married to the birth mother shortly afterwards. So.
And again, Chair, that will come through in the Hansard of that session for those members that weren't there. We'll see that, which I think we'll get next week.
Okay, were there any actions there?
I think we've got the noted, the ones that
Yeah.
we needed to do there. That's fine, thank you.
Okay, moving on then, draft forward work programme. I'm going to refer you to pages 707 to 709 of your pack, and I'm going to ask the Assistant Clerk to go through any changes. Thank you.
Thank you, Chair. So just to say, obviously we're in Halloween recess next week, and when we come back we will have no meeting, but we'll be going on our visit to Maze Lonkesh Development Corporation. So all members should have got the diary invite and the associated papers. So if any member can't attend, I know Pam, you've obviously indicated, but if anyone else can let us know by next week, that would be great. And then our meeting after that then will be the 12th of November, and we'll have a briefing from the PSNI that day on their race action plan, and then department officials on race relations and the refugee strategy and the delivery framework. And we'll also have our legal advice then on clause 27 and the outworkings of the bill, and for participation status in relation to the inquiry.
Yes.
Okay, thank you. I just wanted to pick up on the potential for the NIO to, it's down here as an informal meeting around their new legacy bill. I'm just very conscious that the LCMs will come through justice now, so it's maybe overstepping the mark in terms of possibly getting a briefing here when it should be more justice.
Chair, I reached out to NIO last week. I'm yet to hear back from them, but certainly it's something that we've we've put in train. So we'll come back to you once we've heard back from them.
Yeah, but there's
it
obviously
may
an
well
issue
be
with
that,
justice and
that the position has moved on since
Yes,
since we last
okay.
looked at it.
Okay, members, any other business?
Oh, thank you for
Okay.
today.
Yeah, no, very well. Thank you. Okay, members, so the date and time of next meeting then, so as the Assistant Clerk's just indicated there, so next week's Halloween recess, and then we will be Maze Long Cash. So our next official committee meeting will be on Wednesday the 12th of November, 2 p.m. We're back in this room. Are we staying in this room then?
We can stay in this room, or I think we stay in this room until the end of the year,
Okay,
and then we'll move back if we wish.
okay. Okay, so members, the meeting is adjourned.